let's call the cases of the People's State of Michigan versus Anton Brooks.
Anton Brooks.
Regardless of people?
Joseph and also on the people.
Good afternoon, Your Honor. May it please this honorable court, David Burgess on behalf of Anton Brooks. Your Honor, I'm actually retained on both matters. My office is filing a substitution of attorney, even though I've received discovery in both cases. For some reason, the substitution on the assault with intent to murder case didn't go through. I just asked Mr. Johnson for his approval to sign that, and I believe that's okay. Obviously, he's still the attorney record judge, but I just want to put that
right. And Mr. Johnson, that's your understanding also, sir?
Yes, Your Honor.
All right, very good. Then, Mr. Brooks, you don't have any problem with regard to today if Mr. Burgess just proceeds on your behalf, and then I can let Mr. Johnson go. Do you have a problem with that?
No.
Okay, very good. All right, thank you, Mr. Johnson.
Yes, sir. Thank you.
All right. Okay.
Judge, procedurally, addressing the R&O case and the motion first. Your Honor, I did speak to my client regarding the DNA swab. There was some misunderstanding when he was asked to provide a DNA swab. He thought he didn't understand why I had to provide one because he'd already provided one earlier in another time frame. He wanted time to speak to an attorney. Since that occurred, Judge, and I understand. I mean, a lot of people don't know their rights. And since that occurred, he and I have spoken. He understands that there's a court order. He understands that the people obviously have a pending motion, but at this point, he's spoken to me and he understands that they need a separate DNA swab for this particular case. So based on what we've discussed, Your Honor, he is okay with providing a DNA swab voluntarily. Is that correct, sir?
Yes, sir.
Okay.
All right, very good.
So there's no need to proceed on the motion, Judge. Your Honor.
People okay with that?
People okay with that, Your Honor.
Fantastic. Okay. Let me ask this. He's voluntarily going to do that. Are the people going to feel more comfortable that there's an order in place, at least, so that?
There already is the search warrant in place trying to accept counsel's representations. It's my understanding that counsel's intending to set the A1 matter and the other matter for exam day. All it asks is that the motion be continued to that date. If the samples provided by then, we would just strike the motion.
Got it.
Yeah, that's correct, Your Honor. That's how we plan to proceed. Because
then we can do that.
My next issue is, Judge, since I did receive discovery in both cases, obviously we're probably not going to proceed on the R&O to exam, but we were going to set them both for exam dates for your next available one, Judge. And obviously that's a placeholder more than anything on the R&O. So
got it. And you have discovery on everything.
Yes, Your Honor.
So let me just say this. What are the charges? I mean, I can set them for the 22nd.
That's fine. I'm here anyway. So
that's going to be a day. That's all I'll say.
Okay.
All right. Preliminary examination in person will be set in these matters for July 22nd, 2025, 9 a.m. These are before Judge Barr.
And Your Honor, if I may briefly address the issue of bond.
Yeah.
I'm sorry.
So that what I'm just in terms of judicial resources and judicial time. If the DNA swab is not provided that day, you can send the motion over to me since I am familiar with it. Okay, because I'll be on that day.
Yes, Your Honor. I feel that given my discussions with the defense counsel, I trust that.
Yeah, no, I got that. I believe that everybody has good intentions, but just in case some issue comes up regarding it, Judge Barr will be in B and I'll be in C, and so it'd be better off if I just deal with it.
Understood, Your Honor.
Okay. All right. Yes, that's about.
Thank you, Your Honor. Your Honor, we understand the serious nature of the charges in this case, and we understand there was some misunderstanding. I don't believe my client was trying to obstruct justice or do anything improper in any way. I think he was just exploring his options regarding his rights as it relates to DNA. So I don't think that should be considered as an aggravating situation. Since I spoke to him today, he understands his rights at this point. Obviously, Judge, he's agreed to voluntarily provide that swab. So I don't want that looked on disfavorably as it relates to bond in this case, Judge. Your Honor, I understand the serious nature of the charges, assault with intent to murder. However, my client obviously is presumed innocent in this matter. I believe the bond is currently set at 100,000 cash surety, if I'm not mistaken.
It is.
Okay. Your Honor, he does, when he's home, he does take care of his, I believe, 95-year-old grandmother. Is that correct? And I just want to make sure I get the age right. And Your Honor, his mother and significant other are present in court today in support of him. He does have large family support, Judge. I did meet with the family last week, and there are a number of people that are, he has family members in the community that does live in Ypsilanti, Judge, but even though they're not all present here, Judge, they are in support of him. So he's not going anywhere as it relates to his whole family's in the area, Judge. Again, understand the serious nature of the charges. We understand a PR bond might not be appropriate, Judge, but at least the court, if it would consider a 10% provision. Again, he does help take care of some elderly family members, and he's not going anywhere. Again, his mother and significant other are present in court today in support of him.
Are there other case outside of these? Is he being held on anything else, or does he have anything else?
He does have he is on probation to Judge Conlon, Your Honor. That matter is still pending. He's about to be released from probation in front of Judge Conlon. But obviously they're going to wait to see what happens in this matter.
Right, and I guess that's, I'll hear from the people, but I guess that's part of my concern. At the time these events occurred, was he on probation?
Yes, Your Honor.
Okay, all right. From the people.
Your Honor, on the RO, we would leave that up to the court's discretion. It does sound like maybe that's going to get where people have their grave concern is with the assault and murder. Your Honor, in this case, Mr. Brooks is accused of shooting at a stranger in public with no provocation. The allegation being that Mr. Brooks saw this individual at a gas station, started asking questions, and the individual told him basically to leave him alone, and then Mr. Brooks allegedly followed him and then shot at him at a red light. It was a shooting that was witnessed by 3 people. Identification was not made by those individuals who were all strangers, but there was some surveillance. There was getting security videos from the area. There was the pulling over of a vehicle that left Mr. Brooks' home with a bag. The officers saw taken into the home and then back out the home. And that's where the firearm in this case, that's how it was recovered, Your Honor. There was testing done, and the shell casings at the shooting matched up with the gun that was found in the bag that officers had seen taken into Mr. Brooks' home and then brought out of his home. And so, Your Honor, we do think that Mr. Brooks poses a great danger to the public. This isn't a situation where perhaps Mr. Brooks had an anger at a close friend or relative, and he just perhaps put on each other, make sure they don't have contact. This is a situation with a stranger as the victim. Additionally, shooting outside in public, anyone can get hurt. When bullets are shot, they go somewhere. Unfortunately, in this case, no individuals were struck, but they could have been. And so, Your Honor, based on these reasons, we do believe that there is a danger to the public in general, a grave danger. We're asking for the A1 bond to stay the same. At arraignment, I did the arraignment. I actually had asked for a higher dollar amount. I had asked for $250,000, and so the magistrate decided to give Mr. Brooks a break and just order the $100,000. I do believe it should not be reduced any further.
Your Honor, I would just indicate, obviously, the evidence obviously sounds like it's somewhat circumstantial, and again, I'm not sure that the people were somewhat remiss on if the weapon was actually allegedly fired. I don't know what the situation is, but whether the weapon was allegedly fired at someone in particular or just fired in general wasn't clear as to what that situation was. But again, Judge, I understand the nature of the charges, but my client does still enjoy the presumption of innocence, and I'm asking at least if the court could consider a 10% provision. Regardless, Judge, he does have to address, I believe, the issue in front of Judge Conlon. I'm not sure what the status of that is at this point. So,
is his bond denied in the matter currently in front of Judge Conlon?
Do you know what you're saying? Did he remand you, or did he?
No, he was waiting to see what this was.
Did he set a bond though? Do you know?
No, I'm just hold.
Oh, okay.
Probation.
He's on a probation hold, but he doesn't believe a bond's been set. I haven't appeared in front of Judge Conlon.
The effect of that is that his bond's denied. That's how I would read it, that his bond would be denied pending resolution of that probation violation.
Yeah, right.
Otherwise, there would have been a monetary amount or a bond set. Given a number of different circumstances in this case, the representation, or at least the allegations in this case, and the nexus to the defendant, while it may be some of it may be circumstantial. The court does believe that in that instance, the defendant would pose a significant risk to the public. And further, in looking at it, the other issue that arises is that at the time of these events, the defendant is on probation to another court. So it would be this court's understanding that he may not be entitled to a bond in any event if these actions occurred while he's on bond. But irrespective of that, the court does consider, given the allegations that the defendant is a danger to the public, would view the bond as reasonably set. Actually, in both matters, I'm going to leave the bond as set in the R&O as it is. He has an exam coming up in a few days, and certainly Judge Barr could be free to change those bonds after he hears the testimony in the case. So the defendant's motion to reduce bond at this time is denied. Thank you.
Right from the start, this courtroom feels tense. 2 cases, 1 defendant, and a defense attorney trying to get everything straight. It's paperwork, sure, but behind it, a man facing an attempted murder charge. The defense makes it sound simple, just a misunderstanding over a DNA swab. But here's the catch: DNA is everything in a case like this. One sample could tie Brooks directly to the shooting. July 22nd, the judge locks in the preliminary exam date. That's when it all goes down: evidence, witnesses, and possibly the moment that decides if this case heads to trial. TikTok. Now comes the emotional pitch. The lawyers painting a picture: a man who cares for his 95-year-old grandmother, surrounded by family, not a criminal. But will sympathy soften a judge's view of a violent charge? The prosecutor doesn't hold back: a public shooting, a stranger as the target, 3 witnesses, and a gun that matches the shell casings. The message is clear: they see Brooks as a danger to everyone. And there it is, the final blow: bond denied. The judge calls him a public risk and keeps him behind bars for Anton Brooks. This isn't freedom delayed, it's freedom denied. What would you have decided?